live. This is Foundations of Property Law, and we're into week 6. Thank you for those of you that have joined live. For those watching as a recorded session, please do consider joining us for the live session at some stage, if not for the rest of the unit. By now, you've seen the results of your first assessment, and thank you very much for participating. By way of very general feedback, the results were great. The work was very good. It was difficult to mark in some ways because this was an assessment where I set some different parameters. I wanted you to prepare something that works for you. And tonight, given the substantive content, you'll be in a position to better understand how I mean for that to occur in a more practical sense. I do hope that you will build on the documents that you've prepared, and some of the better responses provided things like flowcharts, dot points, checklists, a series of preliminary questions that needed to be answered before moving into other areas. And the idea of the exercise is that at the end of the unit, you'll have material together which will enable you to quickly identify from a particular problem what area of foundations of property law or areas is being tested. Of course, it's very useful for examiners to create questions that have some degree of ambiguity. And sometimes, if we're really in a bad mood, so to speak, we'll create something which has an obvious false element to it, so that you think it's something, but in fact it's something else. And it's very sad to see in some of the examinations that I've marked over the years, where students have got to the end of the paper virtually, realise that they've been down the wrong track the whole way, and then to their credit have said, sorry, misread the question, went down the wrong route in answering. It's actually to do with this. I realise that now. And had I had time, I would have dealt with 1, 2, 3, 4. So at least you're salvaging something. Some examiners take the attitude, if you're answering the question wrongly, if you're dealing with real property, whereas it should be personal property, then they'll give you a 0 mark. I tend not to do that. I try to find something in the incorrect answer that can justify a few marks. One of the reasons I can justify that approach is that there's not necessarily going to be a right answer. Now, sometimes there is, because sometimes the question that seems to be completely theoretical is not that theoretical at all. And it's actually based on a case from the district court in Western Australia that I or other lecturers may have stumbled across, etc. So even though it may, and we, of course we don't directly plagiarise, but you draw facts from it and you incorporate maybe another case or two and then add to it. I tend to create something that is completely hypothetical, just off the top of my head, but that's not always the case. So what can we draw from these preliminary comments? The first is, you've got to have something that works for you. Now, by that I mean, and I'll give you an example, in the work that I've done all my career, I've had a certain mindset, an approach that works for me. I've discussed this with others, I've shown others, and almost always the response is, yeah, I get it, that works for you, but I do it differently to that. And likewise, colleagues have said to me, oh, this is a really good way of approaching this. And I go, yeah, I see what you mean. That might work for you, but no, that doesn't really work for me. So do you understand? So there's actually a lot of creativity in law, but it is individualised. The end result may be remarkably similar, but the process by getting there may be quite different. So you need to read extremely actively. You need to read proactively, not just reading the material and then moving on, you need to almost look at this in reverse and say, if I was given some obscure set of facts with a little bit of this and a little bit of that, would I be able to identify that in order to answer the question legally, accurately, and appropriately? Now, you might be able to do that. Some people can say, oh, I can pick up on that straight away. And sometimes it's really obvious. But again, as I mentioned, sometimes we do try to write in an ambiguous, slightly obscure manner when it comes to problems. And of course, in practice, you never have a situation where someone will come in and ask you a theoretical question. It's always a problem. And you have to think, in practice, it's even broader. We're talking contract, torts, constitutional, consumer, criminal, whatever it might be. And you need to quickly identify the branches of law and then from there drill down. So please continue to develop something that works for you. Many of you answered the question about your strategy for answering questions based around IRAC or some variation. I tend to use the MIRAC method or the CMIRAC method, which is conclusion, then the material facts, then IRAC. But I don't head it that way usually. I might put conclusion, but you try to make it more of a narrative than strictly applying in an identified way, identifying the facts, the issues, the rules, and the application. Now, I take it you all know what I mean by that, and you could explain the IRAC method if I ask you that, which I won't do in an exam question. One of the good ways of answering a question is to try and identify the main facts. And you do that by some form of chronology. And then, of course, try to identify the rules and the law that go with it. Okay, some other basic matters in relation to the feedback. Most of you referenced your material very well. Please continue to do that. And for a slightly more advanced situation, make sure that you provide the authorised decision for a case that you're citing rather than an unauthorised. If you're not sure of the difference, have a look at some research on that so that you've got some clear guide as to what's authorised and what's not authorised as a report. So not everything that you read regarding a case is the authorised reference point. For example, in the High Court, for the Commonwealth, go to the CLR series wherever possible. Most of you cite your material in accordance with the AGL-C4 very well. So thank you for doing that, and please continue in that regard where you can. Make sure that you try to keep up to date with the law. I mentioned that on some occasion, lecturers will develop questions that are based on real cases. Where we have the opportunity to write the question late in the piece or amend the question late in the piece, such as where we've got a take-home exam, then we might do that because there might be a case that's come through that is interesting and would form the basis of a good question. So if you're subscribing, say through Jade as a citator for the up-to-date material, it might put you in a good place and give you a good example or a good, a good reference point of a very recent case. In the same way that I've indicated that you need to develop your own style, you probably need to identify your favourite sources of the law. Now, a basic distinction, OSPLE versus, say, the legislation website, the official legislation website, Queensland and Commonwealth. But beyond that, some people are Westlaw people, some people are LexisNexis people. But you can go between the two, but have your go-to source of legal information. And when it comes to case citators, there are options available for you from which to choose. You can go to LawSite which is Ostley. You can go to case trace, which is Jade. You can go to first point, which is Westlaw, or case base, which is LexisNexis. You can go to all of them if you like, but you probably want to have a good working knowledge of at least one, and that can be your go-to situation. There is a convention for citing material in addition to the AGLC4 through practice directions of courts where the authorised report of a judgment is preferred in all others. So just to give you an example, if you're not familiar with practice directions, this would be a good one to look at. Practice direction number 16 of 2013 in the Supreme Court of Queensland. Have a look at that and get an idea of what practice directions are all about, etc. When you're answering a legal problem, it's always good to incorporate some element of legal ethics into your answer wherever possible. Now, it may even be just a line at the end of the end or the start of the paper. There are no discernible ethical issues that come to mind or are apparent in this. At least then I know that you've thought about it. It may be, for example, that depending on the nature of the question, you're having difficulty in obtaining instructions, or the question may indicate that your instructions are coming to you via a third party, or there may be something about the instructions that stinks, for want of a better term. So there are ethical issues that may arise. So always be mindful of incorporating something like the Australian Solicitors Conduct Rules or the Barristers Rule into any answer that you're providing. Are there any questions then about that general commentary to do with the first assessment and the process of answering legal problems, and maybe some ideas on how to press forward into the future? Use the chat facility if you like, or unmute the microphone. Okay, I'm glad that it was a useful tool. Thank you, Paris, for that. All right. So in terms of the content for this week, it's week 6, but it's topic 5. So the topic numbers and the week numbers aren't matching up exactly, and we will drift away from one topic per week now because we've built in a little bit of room at the end of the unit, and some of the topics, such as tonight's, are very meaty topics. So odds are we'll still be talking about the registration system for security interests in personal properties under the PPSA and the PPSR next week. Well, that'll be enthralling, won't it? This is a topic which is based around federal legislation. So I'm sure that by now you've identified the importance in foundations of property law of the Personal Property Securities Act 2009 Commonwealth. It became operative in 2012. It really did shake up the whole system. It's extremely important. It's something that's likely to be examined upon in this unit and other property law units. You need to keep it in mind for a whole range of things that might crop up in other units as well. It'll crop up probably in contract law, torts law, other property law subjects, etc. So to that end, you do need to understand the background that led to the enactment to some degree, because it did shake things up a lot. And you need to understand the key concept of the Personal Property Securities Act. In a word, can anyone tell me what's the key word, the key concept behind this act? And it's similar, as a hint, it's similar to the Torrens system. Anyone want to offer a word?
Registration.
Exactly, that's exactly the word I was after. Thank you, Tammy. So the importance of registration is important. You need to understand the process by which this works. Now, perhaps next week, but certainly not this week, we might look at the website, but I'd urge you to do that. There's excellent materials online. Have a look at the website for the PPSR and how to go about registering security interests under the PPSA. A key point is this: you can't register that which you do not recognise. So you need to be in a position where you can recognise where we have a security interest, where we have the option of registering something that is a security interest. So you need to be in a position to evaluate what is a security interest, how to go about registering it, and then importantly, how to go about enforcing the security interests that are available under the PPSA. Now, back in law school in the 70s and the 80s, we used to talk a lot about bills of sale. We don't do that now, but you may see some reference to that type of historic approach, as it were. What is far more important is that you understand the purchase money security interest, the PMSI. All right, so given that this is primarily based on statute, I'm going to ask a favour, and that is, if you're watching this now as a live session or if you're watching as a recorded session, the same rule, please call up the Personal Property Securities Act 2009, Commonwealth, so that we can follow some of the discussions. I'll just pause for a moment to allow you to do that. All right, that's long enough. We'll move on. Given that we're dealing with an important piece of Commonwealth legislation, and we're looking to, and here's a big hint, we're looking to interpret what that legislation is all about. Is there another piece of legislation that comes to your mind that we need to potentially consider in conjunction with reading and interpreting the PPSA?
The Acts Interpretation Act.
Exactly, thank you.
But I read that there's actually a limitation on that with this particular act.
What was that, sorry?
I read that there's actually a limitation on the Acts Interpretation Act with this act. That
Very
it was,
good. Yep,
yeah.
there is. Do you know what that limitation is?
That it's only pre this act, or is it the other way around?
Very good. That's very good. It's a little trick, and that's an excellent pickup. So have a look at sections 1 and 2. We'll start at the very beginning. The Acts Interpretation Act 1901, as in force at the start of the day on which the Act receives royal assent, applies to the Act. 2 says amendments of the Acts Interpretation Act made after that time do not apply to this Act. We don't see that very often. And for those of you that may have studied statutory interpretation with me or whoever it was, would know that there's general presumption that the Act is always speaking. So the PPSA is not always speaking. So some of the general rules that apply in interpretation are limited by those provisions. All right, it's important that we get an overview for the Act. Again, thinking statutory interpretation, what we did during statutory interpretation. What's the first thing that you should do if you're looking to interpret a piece of legislation? Adopting the modern approach, of course. Any thoughts?
I looked to the short title and the commencement first.
Yes, very good. Amy says read the objective. That is Amy Mulqueen. Other Amy, Dr. Amy Lee, says definitions. Yes. I'm thinking something much more general, something much more basic than this. I'll give you a hint. I'll use the word holistic. The purpose of the Act, says Gareth. Yes.
The title, perhaps?
Just for my liking at the moment. Carolyn.
The title?
Title, that's good. Here's what I have in mind. So it's hard to be reading the section titles. Megan, you're getting much closer to what I had in mind. Have a look at all the sections and the chapters and the parts and the divisions. Have a look at the headings, if you like, the contents page, and just go through and get a feel for it. See where most of the provisions are. See where the main emphasis of the Act seems to be. What looks to be important based on the titles. You can't judge a book by its cover, they say, but you can judge a piece of legislation by looking at the content of that legislation by reference to the chapters, the divisions, the parts, and then maybe we look at the sections. So once you've got a feel for it, then all of those things that were mentioned earlier, having a look at the definitions, the objectives, that all makes sense. In the PPSA, we need to look at section 3. So we've been through that exercise of looking at all of the contents. We've got an idea of this Act, and now we'll start to drill down a bit. Section 3 provides an overview of the Act. I'm going to move through this section very slowly because it's important. So work with me on this and we'll go through from the top. So section 3, this Act is a law, well, yeah, that's fine, about security interests in personal property. Okay, so we've got the two concepts. If we're dealing with something other than security interests, this Act probably doesn't apply. If we're talking about something other than personal property, this Act probably doesn't apply because this Act is a law about security interests in personal property. You know, I mentioned you've got to have the flow chart, the checklists. This is the sort of thing that I'm talking about, where you have these threshold questions. We don't talk about the PPSA and then at the end of the 2-hour written examination, realise that the Act doesn't apply because of something that we missed at an early stage. So the Act is about security interests in personal property. So what's a security interest? Well, helpfully it tells us straight away. It's an interest in personal property provided for by a transaction. Not just any transaction, but a transaction that secures payment or the performance of an obligation. So security interest relates to personal property. It also is provided for in a transaction, whatever that is. But the transaction, whatever it is, must secure payment. So there's got to be some monetary value or performance of an obligation. What do they mean by performance of an obligation? We'll see if we can find out. The form of the transaction and the identity of the person who has title to the property does not affect whether it's a security interest. So here we've got more things for our flow chart, haven't we? So we've got the overall gate to say this is what the Act applies to. We've got the basic definitions. We've now got some of the exclusions and some of the ways in which the Act operates. So, you know, as an examiner, I look at these sorts of sections, and I've already said to you, I make things up, I make up scenarios. So I look at that and I think, oh, okay, the Act, it doesn't matter whether the identity of the person is known or not known. So I'll throw that in. I'll throw in an example that's a bit offbeat where we don't know the identity of the person in a particular scenario, and people might say, well, the Act doesn't apply then because we don't know who we're talking. Do you understand what I'm getting at? It's the sort of reverse engineering type situation. So that's the definition of security interest. The definition of personal property, well, it says it includes many kinds of tangible and intangible property. So we've got a definition which refers to the word that we're trying to define in the definition. In short, property is property. Never great, but we've got to work with that. But personal property includes different types of tangible and intangible. What do we mean by tangible? Can anyone give me an example of intangible property? Because we think of, this rule is tangible, isn't it? What's intangible? Shares? Yes, that's ideas. Yep. Not physical property, defining it that way. Okay, so again, for the purpose of your preparing proactively, in the first half a dozen lines of this section, you've potentially got a whole page that you're starting to map out that gives you ideas of threshold questions that deal with inclusory and exclusory situations. So personal property, it includes tangible, intangible, but it's not real property. So somewhere along the line, we need to have a good definition, reference to legislation, case law, a dictionary, something that defines what we mean by real property and what we mean by personal property. And I mentioned in the feedback on many of the assessments that I read, if you hadn't included that basic distinction, it might seem so obvious, but it's not as obvious as you might think. So have some way of identifying with authority. And here's the test. If you ever make a statement, then you need to be able to support that with some degree of authority. So you might think it's obvious that a ruler is a piece of personal property. But the test would be, if you're in court and you make that statement by way of a submission, be aware that the judge might say to you, what's your authority for that proposition? What's the legal basis for you making that legal statement and drawing that legal conclusion that this ruler is personal property? So the idea of you creating this document that I've been talking about is to give you a quick reference to that. You don't have to necessarily look it up. You've already got it there. And you can use this for other units and into the future. So personal property, tangible, intangible, but not real property. So what are some examples of personal property? Motor vehicles, household goods, intellectual property, so that's intangible, company shares. And personal property is known as collateral in certain circumstances. So now we've got another distinction, don't we? So we've got personal property can sometimes be known as collateral. When is personal property known as collateral? Well, it's collateral if it is, or it's intended to be, the subject of a security interest. What's a security interest? We loop back. A security interest is an interest in personal property that secures performance of payment or an obligation. So this becomes a bit of a loop here. You need to work that out for yourself. Questions, threshold questions, identify. Right, so it says here, personal property is collateral if it's the subject of security interest. Well, what's a security interest? Well, we've already defined that, but how is it enforceable? Which is the third element here. A security interest is enforceable against a grantor when it attaches to collateral. Well, what does that mean? So a security interest is enforceable when it attaches to collateral. Well, we know what collateral is, we know what a security interest is. What do we mean by attaches? How does it attach? Well, we've got the answer here. A security interest attaches to collateral when a person gives value for acquiring the security interest, and then in return, the person gains rights in the collateral. Let's go through that again. So a security interest attaches to collateral, and we know collateral is personal property, when a person gives value for acquiring the security interest and then gains rights in the collateral. So when it says gives value for acquiring or exchange, says Amy Lee, when it says gives value, what does that, is there a word that comes to your mind from contract days?
Consideration.
Consideration, Carol, yes, that's the word I had in mind. So maybe that's a way of defining value if it's not otherwise defined. Okay, so we go on and it says security interest is enforceable against third parties. Well, what's a third party? Well, so far we've been talking about essentially the person who gives the security and the person who receives the security. We're talking about the grantor and the grantee in general terms. So a third party is someone who wasn't involved in that transaction. Remember at the start we talked about the transaction that secures the payment? So a third party, you might think that a way of defining the third party is to say a third party is a person that was not involved in the transaction that secured the payment or the performance of the obligation. And we may need to refine that. But a security interest is enforceable against the third party when it attaches, well, we know what that means, to the collateral. We know what that means. And so that's part of it. So we know now that the security interest is enforceable if it attaches to the collateral. Attaching means attaches to the collateral when the person gives value. When it attaches and to the collateral and either the secured party has possession or control of the collateral or security agreement that covers that. So now we're talking about some terms that we dealt with in the last few weeks, possession and control. You know how possession is so important in property law? We can see that common law principle now has flowed into this piece of legislation. Now, if you're trying to read this under pressure in an exam, you haven't got much chance of sorting out an answer, have you? Unless you've really read this carefully. So you've got to deconstruct this so that you've got gateways, answers to problems. Okay, now we get another concept. If a security interest in collateral is perfected, it takes priority over another security interest that is unperfected. So what do we mean perfected? What's this term mean? So if a security interest, we know what that is, in collateral, we know what that is perfected, okay, whatever that means, if it is perfected, it takes priority. What does that mean? Probably means it's better than, or it comes first, over another security interest. Okay, so we can have two security interests, presumably over the same parcel of personal property, because there might be a priority dispute. And so how do we get this security interest perfected? How does that happen? Well, it'll be perfected if we have three things happen. Number one, it has to attach to the collateral. And two, it has to be enforceable against third parties. And three, certain extra steps, possession or control or registration on the PPSR, have been taken to protect the interest. So what that means is that it looks as though you can have a security interest that is perfected even though there's no registration on the PPSR. That's if you've got issues around possession or control. Take that with a bit of grain of salt, because registration is always very important. We move on and it says, security interests are also declared to be temporarily perfected or perfected under the Act. Wow, so we've got a lot of words, a lot of concepts. We need to try and put this into a form that makes sense. So the secured party whose security interest has the highest priority is entitled to enforce that interest ahead of secured parties with secured interests with a lower priority. So priorities do come into it. And I guess when it comes to answering a legal problem on this, you've got to ask yourself, how do we untangle this if two or more parties purport to have a security interest in personal property? How do we work out who's got the highest priority so as to say their security interest takes effect ahead of those secured parties with security interests that have a lower priority? I guess if you look at that sentence, you've got to say, well, I've got to understand what I mean by a secured party. I'll have to have a definition for that and some authority, because it's only the priority that relates to secured parties that I'm really interested in that context. Now, what if we have more than one perfected security interest? What happens then? So between perfected security interests, perfection by control has a higher priority than other forms of perfection. All right, so we've got another concept. We now have to work out what we mean by perfection by control. Once we've worked that out, we can then say that the next level of priority is given, subject to certain rules, to perfected purchase money security interests. Purchase money security interests. We talked about that earlier tonight, the PMSI. And if there's no other way of working out priority between them, the highest priority is given to the security interest that has been continuously perfected for the longest period. All this looks like a flow chart, doesn't it? And you'd think maybe when putting all this together, a nice flow chart would have been the go. There might be a flow chart on the website for the PPSR or the PPSA. Maybe there's some work of others that you can borrow and adapt to assist you in working through this. So do some additional research and read the Act very carefully. So the Register of Personal Property Securities enables the secured parties to give notice of actual or prospective security interest, and it's all about recording the data, and the register is kept electronically. Are we all totally confused, ready to give up, or are we up for the challenge? Have we got the we can get on top of this approach? Of course, the latter applies. We're up for it. Very good. That's excellent. Now, if you look at the Act, it also provides the summary that I'm sort of talking about at the outset, where you get an idea of what's involved in this Act. Chapter 1, sections 1 through 15, deal with preliminary matters, including interpretation. Chapter 2 sets out the general rules relating to security interests, and some key aspects here. In number A, it says general principles. So we need to understand the general principles. So have some idea. I'd have a heading. What are if it's important that we set out the general principles, what are they? Where do we find them? What's your authority for saying this is a general principle? Then B, it says interpretation provisions about possession and control. We've already dealt with that. We were talking about possession and control. So part 2.3 gives you an idea of what we mean by possession and control. We've also talked already about these rules regarding attachment and perfection. So where do we go for more information? we go to part 2.4. Then chapter 2 goes on to talk about the circumstances in which personal property is taken free of a security interest in the property. I guess the concept behind that, and this is 2.5, the concept behind that is it's all very well to have this security interest which affects the ownership in real terms, but if you want to buy a second-hand car, for example, how do you make sure that you don't have all of these security interests, perfected or imperfected, attached to the vehicle? Because you want to buy it free and clear, don't you? So in that regard, to ensure that you take free of the security interest, have a look at part 2.5. E talks about how to work out the priority between the competing interests. So 2.6 deals with priority. And then the rules about transferring interest in the collateral, well, we know what that is 2.7. So chapter 2 provides you with a lot of information about how to answer those questions that seem so daunting when we're reading section 3 of the Act. Chapter 4 talks about the specific rules in relation to certain particular areas. Now, D deals with, C is really interesting because it talks about personal property that is processed or commingled and their priority. And this is the sort of area where examiners like to make things tricky, arbitrarily or perhaps in a quasi-realistic way, by saying, oh, look, now this personal property, it's been changed, it's been processed in some way, or it's been commingled, it's been mixed into, it's been integrated into something else. How are we going to work out this problem now? So looking at part 3.4 will assist you. And we've talked about the intangible personal properties and intellectual property licenses. 3.5 is the place to go to find some initial answers. Chapter 4 deals with how to enforce a security interest in personal property. That third phase, creation, registration, enforcement. So look at sections 107 through 144 inclusive. Chapter 5 provides for the establishment and maintenance of the register, which is really the mechanism behind which the PPSA works, is the PPSR. So we need to understand the register of personal property security. Chapter 6, this is the part that always makes me the most interested. Whenever I look at the role of the courts, I get very interested. And again, if we're looking at answering a legal problem from the perspective of what is the appropriate remedy, you've got to ask yourself questions like, what's the cause of action? What's the remedy that I seek? And what's the appropriate court to ask for that remedy? There's no point going to the magistrate's court to ask for a remedy if that remedy is not available to magistrates to make. Likewise, you wouldn't go to the Mental Health Review Tribunal if you're seeking to enforce a security interest. That's only logical, isn't it? So when you see something like Chapter 6 dealing with the role of courts, it might give you some idea as to a starting point in terms of jurisdiction. What do we mean by jurisdiction? Can anyone describe it for me? Tell me what it means. Any thoughts? We see it a lot, don't we? Jurisdiction. Power to make the decision, says Darwin. Yes, I agree. I think that's spot on. It's the authority of the court or the tribunal to make the decision. So does this court, does this tribunal have the jurisdiction to make the order? Have a look at Chapter 6. Now, given that this is a federal piece of legislation, what's your first thought, what's your first thought regarding where you should go to seek some remedy based upon it. Any thoughts? Probably one of the federal courts. Now, bear in mind, in Federal Circuit Court, yep. Bear in mind that in 1987, I'm pretty sure it was, we had the cross-vesting jurisdiction passed around the states and nationally, which really meant that there's an opportunity for different jurisdictions to hear different matters. State matters, state courts hearing federal matters under federal legislation and vice versa. But generally, matters that relate to state legislation are dealt with in the state courts, and generally matters that are based on federal legislation are dealt with in the federal courts. Chapter 7, how the Act interacts with foreign laws. I won't be asking you a question on that. Chapter 8 deals with rules about vesting of certain unperfected interests. What do we mean by vesting? Has anyone done equity, advanced property law, vesting come into existence? Rights to damages and compensation for contraventions, always something to keep in mind as a potential remedy. Requests for secured parties for information. And Chapter 9 deals with the initial application of the Act. So you can see that I've done this slightly in reverse, in that normally I'd take you to the summary first to get an idea of what this Act is about. But I wanted to raise with you the content of the overview of the Act first, and then you can look at the overall provisions and get a feel for it. So if you haven't looked at that Act carefully already, your task for this week is to do so in a proactive sense. Clearly, my recommendation is that you look at section 3 as that which you have up on the screen, from which you work and you draw your information so that you set it out in a logical manner. And from there, you have your hyperlinks, you have your links to particular operable sections of the Act and other pieces of legislation or case law. Now, thank you for some good comments there. Have a look at the key terms in the study guide. So you'll need to understand what we mean by accession. And we're really talking here about goods that are installed in or affixed to other goods. Attaches, have a look at section 19 of the Act. Collateral, we've talked about that already tonight. Commercial property means personal property other than consumer property. Control, so we do have a definition there. Have a look at part 2.3. General law, when we talk about the general law, we're really talking about common law and equity. Goods means personal property. Tangible, including the following: crops, livestock, wool, minerals, satellites, but does not include financial property or intermediated security. A hard word to say later in the day. So when we talk about goods, we're really talking about personal property that is tangible, which includes a number of things. So you wouldn't talk about intellectual property as goods, would you? And again, that's another little trick, isn't it? You know, it may be that there's a question on intellectual property, but if you answer it from the perspective of that being goods, then arguably you've answered it completely wrongly. Grantor, we've discussed what that means tonight. And a grantor is not just a person that has an interest in personal property per se, but it includes people who receive goods, a lessee under a PPS lease, a transferor in certain circumstances, transferees in certain circumstances, or other people involved in the registration process. Interest includes a right in the personal property, so we need to know what that means. Intangible property, as opposed to intangible, is there. Jurisdiction, we've already talked about that. So have a look at 2, 3, 5, 6 and 7. And of course, the distinction between real and personal. Land, what that means, what it doesn't mean, etc. Land law, personal property, there's a definition there as well. And then it goes on to talk about security interests. All right, I'm going to wrap it up a little early tonight. So just before I start to wind up, are there any questions or comments? You've been very patient just listening to me tonight. I'm sorry that it's been a monologue, but I hope you get the idea of what I'm trying to push for here. Thank you, Amy.
John,
Yes.
John, may I just clarify in my mind the virtue of perfection, and I appreciate that it might be prudent to perfect personal property, but my question is that if I have a deed of security over a piece of equipment, I can enforce that against the person that holds it, and indeed against a third party. But am I correct in saying that the virtue of perfecting that only comes into play if I'm challenged by a priority that someone is claiming that I didn't know about? Is that correct?
Yes. So I just missed the last part. Sorry, Ivan.
So the virtue then of perfect, even though I can enforce an obligation under perhaps a deed of security that I have against a piece of equipment, the virtue of me perfecting that, I don't need to enforce it against a third person, but the virtue of perfecting that is only to protect me in a priority dispute. Is that correct?
Yes. I mean, there are elements of good practice that come into here. And to answer that question, I guess I'd be initially thinking of a few things. The first is, what do we mean by perfected? So we'd need to look at section 21 in conjunction with section 3. And then you're absolutely right. We need to look at that from the context of priority. You don't have to have it perfected to have certain rights, but I think it's good practice to do so. I know that's a bit vague, but I would be looking at section 21 and then considering the enforcement provisions within the context of that. Thank you. Darvel says, if you have a deed, would you still need to register it? I think that's a good question. I think the general rule is you should register first, think about it later. If you don't, you run the very real risk of someone gaining a greater priority than you have in relation.
That's right, John. That's right. I've heard a couple of cases because my younger brother, he works for an insolvency and bankruptcy company, and there was this guy who had a creditor for his car that was a loan from him, but that loan wasn't registered according to the PPA, and then this guy was going through a bankruptcy, and that if that debt wasn't registered, that debt is not a debt. That's how it is.
Yes, or it may become unsecured.
That's right. So if we think of having like a deed, we would still need to get it registered. Just having a deed doesn't mean we've got the priority, isn't it right?
That's right. Deed will get around the consideration issue, but it won't necessarily advance the position under the security interests for personal properties. Thank you. So the challenge for you this week is to make a really meaningful, genuine effort to interpret this Act. And just remember, of course, that the Acts Interpretation Act, have a look at sections 1 and 2 from memory. The Acts Interpretation Act only applies as it was when the PPSA came into effect, received its royal assent. Amendments to the Acts Interpretation Act made after that time do not apply to the PPSA. So get a real feel for the Act, try to work through the definitions, have a look at the website, and start to think about all of this from a hypothetical perspective of the sort of scenario that I might come up with in an exam context to provide ambiguity and, a few little tricks. All good? All right. Thank you again for your patience, and we look forward to seeing you next week at the same time. Any questions, please ask through Q&A, and otherwise we'll see you then. Okay, all the best. Bye.
Yeah.